I will introduce our presenter. His name is Larry Parman. He's the founding attorney, and the owner of Parman and Easterday. And in fact, he founded it in 1985, so we are celebrating 30 years of having a wonderful journey helping our clients. And this firm has helped thousands of clients throughout the Midwest, Oklahoma, Kansas, and Missouri with avoiding the perils of probate. And we're very proud of that and appreciative of the opportunity to be of service to families and help them out. I'm going to keep it brief as to the highlights of his illustrious career. He's written 4 books, and in fact, you'll see a couple of these books that are sitting on the table. Guiding Those Left Behind in Oklahoma, Settling the Affairs of Your Loved Ones, Estate Planning Basics, a crash course in safeguarding your legacy. He also contributed to Stop and Think. 10 Outstanding Advisors Provide Important Financial Advice for You and Your Family. And his most recent book, Above the Fray, Leading Yourself, Your Business, and Others Through Turbulent Times. Thank you. He also served as the Oklahoma Secretary of State and the Oklahoma Secretary of Commerce from 2013 to 2015. He's a current board member of the Oklahoma State Chamber of Commerce and the Oklahoma Council of Public Affairs. And last but not least, he is my father, and I'm very fortunate that he has been a mentor of mine both personally and professionally. So please help me give a warm welcome to Mr. Larry Parman.
Yeah, up to that introduction, right? Thank you, Scott. Welcome. I'm glad you're here. We're going to cover a lot in a short period of time. So these are perilous times in America, and I'm not referring to the current election. Perilous times for all kinds of reasons. I mean, every year, more and more lawsuits filed, divorce rates, long-term care costs exploding. This is a litigious society. People sue at the drop of a hat. And there are all kinds of challenges and all kinds of issues that occur because of that. And for the average citizen, it presents all kinds of problems, most of which we don't anticipate. Because guess what? We kind of walk through life thinking, well, that'll never happen to me. And lo and behold, it does happen to us. And then we see all the bankruptcies that have been filed for the past number of years, and a huge portion of those, significant portion, maybe not huge, that sounds like other things we're hearing on TV, doesn't it? A significant portion of those come because of bankruptcies filed because people have challenges meeting medical expenses. And if you dug down, drilled a little deeper into those numbers, you'd find that that occurs even for people who have, quote, full-time and full health care coverage. So there are a lot of challenges out there, a lot of caregivers providing care for both young children or grandchildren and parents who are into their aging years. We have grandparents, for example, that have adopted grandchildren. And I'm sure many of you have friends who have had that same experience. So, and because of poor estate planning, courts deal with huge cleanup problems. And I know that there are at least a couple of you who have been through the estate planning process, and you know that it doesn't always go smoothly, even when you think you have a good plan. People hear me say all the time, bad behavior can ruin a good plan. So we always need to factor that into the equation when we're making estate planning decisions. Now, most of our clients, when we speak to them, talk about the primary concerns they have. There are roughly half a dozen. The first one is they just want to be sure they pass on whatever they've earned and whatever they've accumulated during their lifetime to their children with the least amount of interference, the least amount of cost, and of course the least amount of taxes. They're also concerned about the fees that can be incurred, and they're also concerned about nursing home and other medical expenses. A new worry that's kind of cropped into the equation lately, this whole idea of creditor and predator protection. So let me give you an example. There are people out there today who live somewhere, Mongolia, Siberia, we don't know where they are, who find the soft underbelly of businesses' computer systems or yours at home, penetrate those, encrypt your information so you can't get to it, and then hold you up for a fee in order to get it back. And of course, we all know about the credit card scams and the calls we get purportedly from the IRS telling you you're 5 years behind due and they're going to come after you and put you in jail. So there are all kinds of things that go on. And we shouldn't forget that sometimes, while we think family members may get along beautifully, they often do not. And so we want to be sure that when we plan, again, we factor all those things into consideration. And here's the new one. And we talk about this a lot. This is not just about the money. This is about passing on the wisdom, the experience, the life experiences you've had, so that your children have an idea of who you were and what you stand for as a human being. And that's becoming more important. We refer to that as our legacy program. And again, we're going to talk more about that as we go through the program. Our firm is a member of the American Academy of Estate Planning Attorneys. We've been members since 1993. It's an organization comprised of about 250 law firms throughout the country. Our membership in that gives us a feel and a capability that's almost like a national firm. So for example, if you leave Oklahoma and you move to Texas or Florida or even Vermont, and questions come up about your plan connected to those states, we can help. We have friends who are members of the Academy in virtually every state in the Union. And you can't imagine what a great resource that is for us to be able to call and bring that help in when needed. The Academy is a great organization. They require us lawyers, to have a minimum of 36 CLE credits a year. In Oklahoma, the legal requirement's 12. So they really hold our feet to the fire. They want us to be consistently, constantly learning about the new things that drive estate planning issues in the marketplace. Academy members also get good recommendations from different organizations, including Money Magazine. Spoke very highly of people, of firms who are members of the Academy, even recommended to consumers that if you're looking for an attorney, go find someone that's a member of the Academy. Susie Orman likewise spoke highly. I think we all know her from television fame, and she also recommends Academy membership. So I appreciate you being here. My guess is none of you woke up this morning excited to go listen to Parman talk about death and taxes, right? That's not what we wake up thinking about in the morning. But yet there comes a time in our lives, sometimes it's early, sometimes it's in the middle of our lives, sometimes a little later, when we really have to stop and think and get real about protecting ourselves, protecting our loved ones, protecting our families. So we're going to talk a little bit tonight about some of these issues. We'll mention why plans don't work. We'll deal with that. But we'll also deal with those other topics. So one reason that people don't plan is, I don't like to call it lack of knowledge, because we all have some intuitive understanding, A, that something needs to be done, and that B, we kind of have a feeling for what we think we need to know and do. But the problem is there's so much misinformation and disinformation in the marketplace. I don't know about you, but when I hear all kinds of conflicting information from a variety of what I think are, quote, credible sources, what I do sometimes is shut down. You know, I tend to say, well, now, wait a minute. I mean, why does this go so confusing? Why can't I dig through all this? And why can't I find out the truth? Anyone here have that experience? Like every day? So there's a little bit of an issue here with that too. And so the challenge we have is it's not what we know, it's not what we don't know, it's what we don't know that we don't know. Because those are the blind spots in our lives, and that's where we can really run into trouble. And the other problem we see too often is that, almost in an anticipated way, we sometimes receive, hold as true, information from people that you might think should know, but really don't. Let me give you a great example of how that affects me. If any of you came to me and asked me to handle a criminal case for you, you are going to jail. And you're going to be there a long time, okay? So there are attorneys that simply because they hold that certificate think they can do anything. And I admire that, particularly in small towns. I'm from a town of less than 1,500 people in northwest Missouri. And the two lawyers who are in that little town of Albany, Missouri, know more about more things in the law than I've ever forgotten. But if you take them very deep into estate planning, that plow has dug a pretty shallow furrow. But again, you can't, it's anticipated. People walk through their front door, and one person wants a divorce, another person wants a title cleanup, another person wants a traffic ticket taken care of, sometimes somebody wants a probate. So practice in small town America is a lot different than it is in our practice. We don't go wide, but we go deep. Estate planning and business planning, elder law planning, that's all we do. And we try to go as deep as we possibly can in that arena. But back to the problem. The problem is sometimes knowing is not enough. We can know what we need to do, but yet we still get hung up, and there are still things that don't happen. And we don't feel comfortable. We don't feel like we're sitting in front of someone that we can trust, who we know that will put their arm around us and shepherd us through that process and get things done exactly the way we want. And again, our primary enemy and yours about this whole process is that word. It's procrastination. It's putting things off. I mean, I just wrote a piece the other day, and Scott and I were talking about the number of reasons that we've heard about why people don't move forward and plan. I mean, it's an amazingly long list. And it doesn't matter, but however that person feels and whatever thought they have is legitimate to them, right? It's real to them. But it's a challenge because the more you procrastinate and put things off, the more you're apt to be a victim. We're going to cover not only what we do, we're going to cover how we do it, and we're going to cover why we do it. So most of the program will be talking about what we do and how we do it. And the how part's going to first deal with what not to do, and we'll come back and talk about the better way to do it. And then I'll tell you a little story at the end about why I do it. Specifically, we're going to look into traditional estate planning, why it fails a lot of people. We're also going to look at why most plans don't work. We're going to talk a little bit about legacy planning, that whole area of being sure that when we leave, and we never know when that is, that we're not just a blank box on the family tree. That when that name Steve or Jim or Larry or Josh appears for someone decades down the road, a trail is left of what was important to that person and what they stood for. And we'll identify the most critical parts of the estate planning equation. We'll come back and address a few questions at the end. So I want to thank you for being here. Scott already covered all these points. I know we've done that. The last time I went through this in a program similar to this, I had told everybody to turn off their telephone. I said, let's do it now, get your phones turned off, and 5 minutes later, my phone rang. So there you go. So before we go further, let's talk about a new context. Look at Aaron's pulling out his phone and turning it off. Let's talk about looking at the world in a completely different way as we enter this estate planning world. And let's look at it in a way it's important because it's often overlooked, and it sometimes leaves a new epiphany. And here's the point, that traditional planning, when we sit down and we think about planning, even estate planning, we tend to think about the what? We tend to think about the money, right? We tend to think about, well, who's going to get what, when, and how's that going to work, and who needs what, and how do we divide that? All that's a paradigm around the idea of the money. And don't get me wrong, that's important. The money's important, as are all of these. Avoiding the probate, minimizing the income tax, avoiding the estate tax if there is any, so on and so forth. And even controlling those distributions. Because guess what? It's a whole new world out there. And from the time I started compared to today, people think much differently about when they're willing to turn over control of the money to the children. There's a lot more serious discussion about that today. And part of the reason is because of all the uncertainty and the unsettled lives that we have around us. 50% divorce rates, for an example. So this is not an easy task. So let's get started. We don't believe that traditional planning should be the sole focus. We also believe that we should look at the legacy planning. I've given you a little bit of a thought about that. And we start that discussion with having you identify what your defining moments are. What were the things that were transformational in your life? What were the things that when you look back on them, you go, wow, that was really cool? I mean, that was really a neat experience. That profoundly changed my life. That person really had an impact on me, or I had an impact on them, whatever it may be. In my case, there are a number of them. You know, that's the four of us together, daughter, son, me and Darlene. That's, I don't know who that is in the middle on the top, but that was a long time ago. That's Stan, my brother Stan and I with my mother Avis. She just turned 93 in Northwest Missouri about 2 weeks ago. She's doing well. And we were in Washington, D.C., Josh and Jessica, for some gala in D.C. on July 4th. Oh, wow. Now, you can imagine, you know how hot it is in D.C. on July 4th. So it was not a cool evening by any means with all that regalia on. And then we're at another event. I don't know where that was. In the top right-hand corner, that's a picture of me at the top of Mount Kilimanjaro. Well, that was a defining moment for me. And by the way, there weren't many people with my color hair on top of that mountain. You know, that's a young man's game. That's for young lungs, so to speak. So all of you have defining moments, right? Things that have really had a big impact on us. And we think that that context is important to think about. We think that that opening our minds to that really unloosens the hinges to help us make more high-quality estate planning decisions. And we can think about those things and know their importance and know how that might be transmitted to our future generations, to the next generation behind us. Pretty critical. So as you think about estate planning, ask what's important to you. You know, some of these things, I'm sure. But my guess is, if you go through and prioritize those and look at things like what your core values are, how you want to leave the shared wisdom that you've accumulated and pass that on to future generations. Many of you have had tremendous contributions to your community, to your church, and of course the financial side. Our only point of having this discussion is to open you up a little bit to the idea that this is just not what it's all about. That's important. But how well this works will many times turn on these items as well. And they shouldn't be ignored, and we don't. So when you look at those categories of what's really important, you know, my athletic prowess won't match Michael Jordan's. And chances are most of us don't have the ability to pen prose like Shakespeare. We might be good writers, but they might not be talking about us 200 years from now. So all of us, though, have gifts. All of us have these special talents and these special gifts that are unique to our DNA, unique to us. And we think it's important that you get clear about those and that you stand up and be willing to share those. So, what's the most important ingredient to you of a good plan? You don't have to answer that now, but think about it. Think about that a lot. A couple comments about why plans fail. I call these drive-through estate plans, the fast food version, the down and dirty. A common refrain we hear when people walk through the front door is, well, I don't have very much, and I'm not sure I have enough to even worry about planning. But let me remind you that I don't care whether that number is $3, 300,000, 3 million, or 3 billion. What you've worked all your life to accumulate is important to you, first of all, because our most important objective for you, both from a financial planning point of view and an estate planning point of view, is that you are taken care of and you are protected during your lifetime. Because with today's laws, there's not a whole lot of incentive, unless you just want to, and that's a legitimate reason, by the way, to make significant lifetime gifts, particularly if they imperil your own financial well-being. So our top priority is to be sure that you take care of yourself. Back to the fast food documents. What too often happens is, because people don't think that what they have deserves careful planning, they go for the simple, easy 5-page document and 5-page answer. And they can pull that from Office Depot, they can pull it free off the internet, they can go to the end of a strip shopping center, and I'm not criticizing any lawyer who's there, and get a cheap plan put together. And that may not always be the best answer. We had an example come up this week in the office where a child of one of our clients actually about to be client now, didn't think they needed to be a client, was going to let their daughter do it because she's an attorney. But she's never practiced a day in estate planning, and it just is not familiar with it. So when we came time to review her suggestions compared to ours, it was like night and day. Not critical of her. In her area of practice, I wouldn't have stood a chance. But in our area of practice, she didn't stand a chance. So again, just be cautious, be careful of the drive-through documents. The best way to get a handle around this topic is to give me permission to tell you a story. And the story is about Bill and Mary Jones. All of us tend to remember stories more than we do lectures. And this is not a lecture. This is a story about a couple. And what I want you to do, as you hear me share this story, is I want you to walk in Bill and Mary Jones's shoes. I want you to live the life they're living, and at the same time, I want you to transpose what they're experiencing back into your own. How would you handle that? Are you prepared to handle that? What would you do if? So put yourself, walk in Bill and Mary's shoes. Let's find out a little bit about them. They've accumulated a nice size estate, about $700,000 consisting of an IRA, their home, some bank accounts, brokerage accounts, family farm, title in his name. He inherited that from his brother. So its title is joint tenants in common. It's a key point to remember. And they also he has a business. And that business is likewise titled in his name with his brother or with his partner. So he has a business, has a farm, both titled in his name. He inherited the farm, started the business with a partner. Many of the other accounts are joint, not the IRAs. All of us know that IRAs are titled in one person's name. They pass to the beneficiary that we designate when we set those accounts up. That's a little bit about Bill and Mary Jones. Now, some of you may be single. Some of you may be thinking, well, I'm telling a story about a couple. Does any of this apply to me? And the answer is yes, it will, because Bill is not going to live through this entire story, as you might imagine. At that point, Mary's going to become single, and all the points then become relevant to those who are single. They have a family, John and Susan. I love this picture. Because I don't have to tell you anything about John and Susan, do I? You know, Susan's a young CPA doing well in her career, 2 children. And John, on the other hand, he's trying to find his way in life. It's a little kumbaya, whatever. Out in California, no harm intended to the West Coast. But every time he calls John and Mary, he always ends his conversation by saying, oh, by the way, Mom, I need more money. I need more money. So John's still trying to figure it out. And he has some issues in his life. That's what's going on in their family. Now let's assume that Bill and Mary have this thought. They don't get invited to a VIP program, but for some reason they find their way into our office. And we go through a consultation with them. And we sit and explore, we ask them lots of questions, find out about what's going on, and Bill and Mary just can't quite seem to get there. A lot of other priorities going on, but we tell them, okay, well, here's some of your options. You can do nothing. You can be like that couple that I saw years ago driving down the road in an old beat-up Volkswagen, and the bumper sticker said, "This is my children's inheritance." You know, that's always an option. The other thing they can do is they can do nothing, and they can die intestate. Who can tell me what that means? You die without a what? You die without a will. You die intestate. Now, the key point to remember there is that even when you think you're doing nothing and you die intestate, guess what? The state of Oklahoma has a plan waiting for you. And they're going to plug you right into that plan. And it wouldn't take us but about 30 seconds for you to figure out that you wouldn't like Oklahoma's plan for you and your family. But it's amazing how many times and how frequently people let Oklahoma do their estate planning for them. So we talk about estate planning. We can put everything in joint tenancy, and boy, that's a powerful concept, yet so dangerous. Joint tenancy is when you have how many names on the title to the property? 2 or maybe even more. So here's how it works. This is an asset. This is a piece of property. This is a CD, a bank account, a farm, anything that will hold two people's name on it. A and B. Joint tenancy with rights of survivorship. What that means is when one person dies, the survivor owns it all by operation of law, no probate, no questions asked. First name drops off by death. The survivor owns how much of it now? 100%. All of it, 100%. That's joint tenancy with rights of survivorship. Joint tenancy in common is a little different. By contrast, when the person dies, his half undivided interest goes down to his heirs. Most of us are more familiar with survivorship than we are tenants in common, although if you've inherited property, you likely own your property, if it's with a sibling, as tenants in common. So we talk about that. And people like joint tenancy with survivorship because, as I said before, transfer by operation of law, no probate on the first death. Why is that? It's because, remember this rule, probably a writer downer in the back of your book. Only property titled in one person's name has to go through probate. Only property titled in one person's name goes through probate. How many names on the property? 2. Therefore not required to go through what? The minute the death occurs, now how many names on the property? Now what's this property subject to? Probate. You get the point? Now, here's what happens, and this is why this is so dangerous. What too often happens is, down the road, their surviving joint tenant, mom or dad, suddenly hears from somebody in church or somebody they're playing bridge with somewhere that you have all this property title in your name, you need to start putting your kids' names on the property. Put the other name on the property. Boy, that's beautiful because now when mom dies, no what? No probate. But the minute you put your child's name on property you own, your property is now subject to the creditors of your children. And there may be all kinds of other tax complications because when that name goes on that property, that's a gift. And so now you've left that child with the legacy of having to pay more tax when you die and they sell the property than you're required to pay by law. Now, how silly is that? All for the seeming convenience of creating successive joint tenancies. So again, a powerful concept, but it can be very, very dangerous. So we have to be thoughtful about its use. We talked a little bit about a bare bones plan. We're going to take a closer look. Or you can create a complete family wealth trust. So what do? What do you suppose they do? They came in confused, they couldn't get focused, they couldn't make decisions. And by the way, this does require a decision. You know, when you decide you're going to set up a plan, it requires not just one, not just a decision about who you're going to work with, but a lot of tough decisions sometimes about family members and who's going to do what. And we'll take a look at that. But they get distracted, so they do nothing. They walk out the door. Some of the worst calls we get in our office is when people come in and don't do anything, and the children call back 2-3 years later and say, we see your material, we know mom and dad came in, we want to talk to you about the plan they created. Didn't create a plan. Doesn't happen a lot, but when it does, it's very frustrating for everyone. Now, little side story. Bill and Mary have neighbors, Ralph and Ruth, and their 2 children, and of course, Rover. Can't forget the dog. So keep in mind what happens here. On this side story, Ruth all of a sudden is diagnosed with dementia. It elevates into Alzheimer's. She has that entire long nursing home experience, a lot of money every month, right out of the pocket. They didn't have long-term health care coverage to pay for it. Couldn't get qualified for Medicaid in time. Stayed in the nursing home for a long period of time. And by the way, that's a higher number now. They just had a terrible financial disaster on their hands. And whether it's any of these kinds of care or not, it could be in-home, could be adult day care, it could be the actual nursing home. There are only 5 ways to pay for that, and there they are, and you see them. And again, this is in your material. Most of what we're talking about is going to be in your material in one way or the other. That'll be a good reference for you to go back and look at later. Pay for it out of your own pocket. Long-term health care insurance, you can apply for very limited Medicare benefits. Throw that one away. I want you to completely disregard that. Sometimes people come in and say, well, I know that Medicare will pay for this, won't it? Medicare pays for your doctor and hospital, not your nursing home. That's Medicaid. Now, there's a little sliver of a window where you might qualify for 100 days of long-term health care coverage through Medicare, but don't depend on it. People don't even get it right when they know they might qualify for it, and then they lose the qualification. But we're talking about a long-term solution. You can become eligible for Medicaid benefits, or perhaps if you're a veteran, you might qualify for some of the programs there. But generally speaking, if you can't get into one of those slots, you're going to pay for it out of your own pocket until the money's gone, if it lasts that long. And that's not a bright future. And that's what happened. Finally, Ruth died, but in the meantime, Ralph and Ruth had to file bankruptcy, lost everything. And at the end of that experience, he was down to his Social Security income. Not a pleasant place to be. Nothing left to pass on to the children. Now, back to our main protagonist. Bill has a stroke. So here's the question. When Bill and Mary left our office with no plan in place, now Bill's running into a health issue. Now he's incapacitated. What legal authority does Mary have to act on Bill's behalf? What legal authority does she have to make health care decisions for him? What about financial decisions? She'll get a break on jointly owned accounts. That'll be fine until she has to deal with his business partner or deal with the farm. Then all kinds of issues are going to come up. It'll even come up with respect to his IRA or his 401k. So there's no legal authority for Mary to act on behalf of Bill. So what does that mean? What does that translate into? If he becomes disabled, no longer able to care for himself, act on his own behalf, then what will happen is we'll have to go through a living probate because there's no one here to act on his behalf. A living probate is that court process where you take everything, somebody goes into court, they apply to be your guardian, they apply to be your conservator, etc., and it's intended to protect people who can no longer act on their own behalf or protect themselves. And this is a miserable deal. I don't know if you've read stories about guardianships and living probates, the Groucho Marx story, where the 26-year-old woman came into court and wanted control of the multi-million-dollar estate, et cetera, et cetera. It gets pretty scary because then too often you have too many people competing for that responsibility. Well, who's the court going to appoint? If Mary's still alive, well, she'll be appointed for Bill. That's not an issue. But what happens if she's not? And we'll get to that point here in a minute. It's humiliating, it's time-consuming, it's costly. And here's how I like to describe it. If you're a husband and wife, why would you want to put yourself in a position where you have to go stand in front of a person in a black robe you don't even know and get their permission to spend your money to take care of your spouse and pay me to help you do it? That makes no sense at all to me. Now, down the road, Bill continues to have issues. He passes away. What do we do now? Is there any plan in place? Is there anything that says everything I have I leave to my loving wife Mary, and if she does not survive, to my 2 children? There's no plan in place. So now we're back into this whole intestate thing. The joint tenancy property we know is going to go where? It's going to go to Mary. We're going to be okay on that. But the very minute it goes to Mary, now her assets are subject to what? Probate if something happens to her. So when Bill passes away, now we get into this big issue that most of us have heard about, this death probate situation. Now, people don't like death probate. Well, first of all, let's talk about what it is. It is a legal mechanism to do for you what you can no longer do for yourself. The court, in effect, injects itself into your life and makes transfers of property to either people you've designated in a will or another document, or if none, then according to the laws of intestate succession. So in other words, the court's acting as your agent. They're doing for you what they're required to do because that property has to go somewhere, right? And the legal system has a way to finally resolve those kind of dilemmas. But what happens is when there's a death, all the assets are gathered, an inventory is taken, a valuation is put on that property, taxes are paid if due, creditors are paid off if I didn't say that before, and then finally the property is distributed. Again, either according to the will or according to the laws of intestate succession. Make sense? That's what a probate is, and that's what it's designed to do. So why do you avoid it? Well, people talk about 3 or 4 major reasons. One that many don't think about is that it's a matter of public record. And there are a lot of people that don't want their stuff exposed to the public. You can walk into the courthouse and you can open the probate record of anyone who went through it. And you can find out all the details of their finances. I'll never forget a case I was involved in Missouri years ago where one competitor actually used it to gain information about his competitor, who he had a contractual relationship to buy the business, and used that as a bargaining tool to get a lower price. So all kinds of funny things happen when legal matters and financial matters are a matter of public record. People don't like the time consumption. An easy probate's going to take anywhere from a year to 2 years. Some of them have taken extraordinary lengths of time. Elvis Presley, 13 years. Howard Hughes, 20, 30 years? And the stories are legion. And if you've been in our office, you've seen the charts on the walls about how long it takes. Really, really smart people. The Chief Justice of the United States Supreme Court died without a will. So there are really smart people that don't get this done the right way. And it's really sad when you see that happen. And of course, the money. People don't like to pay the expense of walking through this, and it can be crazy. Sometimes you get a break, sometimes it doesn't cost all that much, other times it can just be an exorbitant amount of money. And if you own property in more than one state, then you're going to have to go through multiple probates, what they call the ancillary probate issue. Not too much of an issue on death taxes. Oklahoma eliminated their state inheritance tax a few years ago. Hoorah. And the federal exemption now is high enough to where it doesn't hit a lot of people, but boy, when it hits, it knocks you down because the rates get over 40% and it can end up being a lot of money pretty quickly. We don't know what the future of that law will bring. That law has been changed about 30 times since 1913. And it's out there just open for the vagaries of whatever the congressional mood and the presidential mood is at the time. And by the way, the 2 candidates today have differing views on what the future of the estate tax should be. So we don't know what's going to happen. It's going to come and go, come and go, come and go. One thing we must plan for, though, is we know that there won't be any guaranteed certainty. It's not a matter of the United States Constitution. It's statutory, and that can change on a whim. So, no plan. So what is there left to remember about Bill? And when will those memories fade? I was at a meeting the other day and somebody asked a very good question. There were about 40 of us in the room. And the gentleman at the front of the room said, how many of you can tell me the first names of your 4 grandparents? Well, most of us could do that. So let me see, let's just do it here. How many can tell it? How many know the names of their 4 grandparents? Okay. How many of you know the first name of your 8 great-grandparents? How many of you know the first names of your 8 great-grandparents?
I don't know any.
Yeah, see, isn't it interesting? See how quickly it fades? So again, no mark there left for Bill. And again, that ties back to that whole idea of legacy planning that we talked about earlier. So a bad plan can be represented in the points you see there on the slide. No protection from living probate. You know you're going to go through death probate if you do nothing. And you might be subject to the laws of intestate succession. The nursing home expenses might absolutely bankrupt you. And no way to pass on those values. Now, we have Mary living. Here's what we hear from clients today. Remember, you're walking in Mary's shoes. You may share some of these thoughts. They're concerned about what happens if a spouse remarries. What are the implications of that? Folks, we have people, when I started this practice, we didn't talk about these things. Now we have clients in their 90s getting remarried. 2 other clients of ours in their 90s. I think we ought to get a brokerage deal on that someday. Don't you? Jimmy, we ought to get something out of that. Yeah, exactly. So the world's changed. Attitudes have changed about remarriage. It becomes a little bit more of a concern today than it used to be. People are concerned about lawsuits, creditor protection, predator issues, etc., and then finally the nursing home expenses. Mary now has the full estate. She's either received it through joint tenancy survivorship or she's gone through probate and she has it that way. And by the way, if she had to do it through intestate succession, she wouldn't get all that. She get part of it, but not all of it. And she has total control of whatever she has. Now with no plan in place, you're 2 steps ahead of me. You already know now what she's going to face as she goes through her life, right? So let's just take a quick trip with her. This is your life. Think about this in that context. You're going to live a while, ladies. You outlive us guys. I know. Yeah, look at her. Look at that smile. She's a happy lady. A friend of mine said, well, how many busfuls of little gray-headed men have you seen on their way to Florida? None. You know, they're all ladies. They survive us. Just part of the actuarial calculation. She's going to live a while. Now, guess what? Ralph shows up.
Stay away from Ralph.
Ralph shows up. Man, the casseroles, the steaks, the meatloaf, I mean, it's all there. Some of you are smiling. You've seen this picture before. But here's the problem. I'm not going to spend a lot of time on this, but here's what can happen, and here's what we have to deal with. When we have multiple marriages and children by those marriages, we get into all kinds of issues because there's such a temptation that titles get changed, beneficiary forms get changed, the designations get modified, and lo and behold, before you know it, all these things occur, and now Bill and Mary's children are suddenly sharing everything they had, if that. Because guess what? In that second marriage, if Mary decides to put Ralph's name as a joint tenant on her property, guess whose children are going to get that property? Not John and Susan, right? Rover will have a better chance of getting that property than John and Susan. It's going to go to Ralph and Ruth's kids. So all, just be alert. Those are the kind of things that can happen. Healthcare powers. I can't tell you the number of times that in our own firm, people walk through the front door and they think they have the healthcare powers to take care of mom and dad, and they don't. Because mom or dad signed a subsequent agreement giving it to the new spouse, who maybe they've been married to 8 months. So again, life's complicated today. That's why our job and your task and the issues you're going to wrestle with as you walk through this are a little more complicated than they were a few years ago. Mary's going to live. She's going to continue to have that smile on her face because if she manages it well, those assets will continue to grow. But she's going to run into issues too. Huntington's, Parkinson's, Alzheimer's, et cetera, et cetera. She may have health problems. That's the peril of living to the older age. Both my grandfathers, died when they were 65 of a heart attack. You know, one was running out the high school gymnasium at a basketball game trying to get to his nitro in the pickup, forgot it, didn't put it in his pocket, and died in front of 3 children on the way out the door. So it's a different world. You put in a stent, you do 3 bypasses, and you live another 20 years. But boom, then all these hit you. And Mary becomes afflicted with Alzheimer's, unable to manage her affairs, has the nursing home experience, has to deal with, well, who's going to pay for that? Who's in charge of making all those decisions? What about those assets that they've accumulated? That 700, 800, now $1 million, $4 million, $3, whatever that number is. How much of that's exposed to that challenge? And how long is she going to be in that nursing home? And we darn well want to take care of her and be sure that all that money's directed at her and be sure that nobody does anything with it during that period of time. But now you have no plan. And so now how's this going to be resolved? If they're lucky, they'll have an agreement and only one of them will go to court. If they are not lucky and they can't agree on who's going to take care of mom, then you're going to have a catastrophe. And they're going to go in and suddenly 2 children that otherwise might have had a good relationship will now be at loggerheads over who's going to take care of mom. Because guess what? Very seldom do they say, well, let's share this responsibility. It just always doesn't work quite that smoothly. Eventually, Mary will pass on. And we know, like Bill, there may not be any taxes due because her estate did not grow to exceed that $5 million exemption amount we have today, $5 million plus. No taxes due. That's not the problem, but we're going to have some expenses. We're going to have some expenses of settling this estate, and we're going to have the expenses of the nursing home. And so before you know it, we've spent a significant amount of money, all of which could have been eliminated and avoided. That's the key take-home point from that slide. Those are monies that didn't necessarily have to be paid. And there's no message on the family tree. There's a name that might as well be written in disappearing ink. Because down the road, a couple of generations, people are not going to remember a lot about Bill and Mary Jones. Now they're both gone. Now our clients tell us, well, all this money is going to go to John and Susan. What are the risks there? Well, the risks are that maybe their marriages aren't stable, and we're concerned about that. We're concerned that maybe they don't have the financial maturity to take care of that money as they should. And then what about this whole thing of lawsuits and money issues and so on and so forth? Well, if our friend John can't manage his credit card or has a drug issue or any number of things, then that's a problem. What are you going to do? Are you going to write John a $350,000, $400,000, $500,000 check and say, have a good time? Does that make sense? I want to see some shaking heads. That'll make a lot of sense. And see, that's so contrary to what we may instinctively feel. We'll give the kids the money. They need it. Give the kids the money. Well, there's a smart way to do it, and there's another way to do it. So let's look at them. Well, as it turns out, Susan, sharp young woman, has a little bit of an issue with our buddy here, Jason. He's not working very hard because she's the breadwinner in the family. And so he spends his time helping out a little bit and at the pool hall and wherever, and works whenever he wants to. And by the way, the minute Susan inherits that property, think about this, what is Jason, going to want her to do with those assets and that money? Put them in an account or an investment with how many names on them? Everybody clear about the implications of that? At that very instant, she just lost the separate inherited property status of that property, of those assets. Gone, forever. In a divorce, that's now marital property. Smart? Well, maybe not. You'll have to decide. But, second issue is, what about the financial maturity part? Are they ready? Are the kids ready to take care of those those funds? And what about the walking liability we know is John? I mean, is he really in good shape to take care of all this? I mean, this kid has a high school diploma. And who knows? But there's a lot of uncertainty there. So here are some of the ingredients of a plan that's ineffective. You can see them, you can read them. No protection from living or death probate. No protection against nursing homes. We're not going to worry about federal or death taxes too much, but what about remarriage protection? What about divorce protection? What about taking care of and properly managing our funds for the long-term well-being of our children? And in many cases, an outright distribution where they're handed a check is not the way to do that. And what about the life values? Again, I'm hitting on that quite a bit to make the point. We think that's an important piece of this equation. So, let's talk about Plan B. We think it's a much better plan, a much better option. We're going to give them a do-over. This time they're going to come in, they're going to go through the options, they're going to retain us, and we're going to talk to them about the idea of legacy wealth planning as opposed to estate planning. We're going to talk to them about protecting the financial wealth, but we're also going to start incorporating the legacy elements into it and walk them through that process. One of the primary instruments that we're going to talk to them about is a legacy trust, a living trust, a revocable living trust, to be the foundation of the estate plan, no longer a will, rather a trust. Smarter idea, better idea. Here's why. Only 2 steps to creating a plan. I'm going to give you a little quiz, so I want you to stick with me here. Every trust that's been created since the 1400s, I think, or 1200s, sometime after the Magna Carta, every trust that's been created has 3 parties to it. Trustors, trustees, and beneficiaries. Repeat those words for me. Trustors, trustees, and beneficiaries. Every trust has those 3 parties in them. Now here's the test. There are 4 words that describe these 3 functions. The first word has two words attached to it. Trustors own and create. They own the property and they create the plan. Trustors do what? Own and create. Great job. Trustees, what do you suppose they do with the trust assets? They manage. Great. The M word. They manage the assets. So again, trustors own, create, trustees manage. Easy one. What do the beneficiaries get to do with the money? They get to spend it. They are the ones entitled to receive all the income and all the principal during the life of the trust. So now here's the quiz. The trustors do what? Own and create. Trustees manage. Beneficiaries spend. You guys now know more about estate planning than 98% of the lawyers in Oklahoma. Believe me. So they create a plan. That's the first step. And during that process, after that's created, it's business as usual. No new tax forms. Everything flows through to your 1040. No new actions to take. Nothing changes. Your tax for your 1040 looks exactly like it did before. There's only one note. In a revocable trust, you have the right to change, modify, amend this document anytime you choose as trustor during your lifetime. That means you get to keep total what? Control. Total control over this process. Don't let anyone tell you that if you create an estate plan with a trust, you lose control. Not so on a revocable trust. Is that all there is to it? We're finished, right? Not quite. There's step number 2. The magic is how we hold title to the property. Now we've worked a little bit here about the implications of property ownership, and we already know the core rule is that any property title in one name goes through probate. Great. Good group. So one of the purposes of setting up this trust is to ensure that we have how many assets titled in one name? None. And that is called funding the trust, or transferring everything that we own into that trust. Make sense? 3 exceptions. Retirement accounts, like 401ks and IRAs. Those still have to be titled in your individual name. We connect them to the trust via beneficiary designation. Annuities, same thing. Life insurance. Life insurance depends on what it is, whether it's term, cash value, etc. But the general rule I want you to remember is that everything you own needs to be titled in what name? Needs to be titled in the trust name. If you're going to create a trust, get it in there. So we do that, and during that process, when we're alive, it's a standby device. Protects us if we become disabled. We avoid the probate, etc., etc. And it has protections in there that we're going to talk about right now that deal with some of the issues we saw earlier. So again, all the way through those processes. Now, quickly, stroke. Problem? Living probate? How many assets, title, and Bill's name? Because with our trust, you get all the ancillary documents you need to be sure that you have the legal authority to act on behalf of your spouse. The trust will do part of it, a durable power of attorney will do part of it, healthcare powers will do part of it, etc. It's that whole compendium of documents working together that avoid this problem. No loss of control, etc. Now at death, how many properties titled in one name? And we avoid the probate. That's the beauty of this. And when you create a plan with us, we're going to have you walk through that legacy wealth plan element as well. Taxes, here's what we know. Every plan we do will protect you up to the maximum amount of the estate tax exemption at that time, whether it's $4 million or $20 million. We just can't tell you what that exemption will be at the time of your death. All we can do is remind you to come in. If your estate's getting to the point where it's bumping up against that, you should be talking to us once a year, just so that we can help you manage that and plan so you don't have to send taxes to the federal government that you're not obligated to send. Now, what about our friend? So now in this case, with the Legacy Wealth Trust, we're going to have a conversation with you along these lines. How do you want to treat, how do you feel about remarriage? And do you want, Josh says not very good. So the point is, we're going to talk about that. And if the clients tell us that we want to be sure that whatever we've accumulated together, that for as long as either of us are living, that the assets we've accumulated go to our children and our children only, then we're going to show you how to do that. But that's a very important conversation we didn't have just a few years ago. And we want to be sure to keep everything in your family. So you don't have this dilution, you don't have this bleeding off, you don't have this diversion or maybe even outright theft of your property going somewhere else. And it may be appropriate, may not be appropriate, to have a discussion about what you want to do about the long-term health care issues. You may want to address that, you may not want to address that. Some of you may have long-term health care insurance, others may not. If you don't, then at some point in time, we should have that discussion. Now, as Mary goes through her life, encounters the same situation, we still have to address that issue of where that money's going to come from. And without long-term health care insurance, she's going to pay for it out of her pocket. It's going to come out of her estate. And thank goodness, At least by this story, she has enough to cover that, right? And that's good news. But we find that this is a sensitive, delicate topic with a lot of our folks, because long-term health care it's not cheap. It's expensive. I mean, its price is based on your health and your age. And the older you get, the more expensive it is. So we all get to a point where we say, you know what, I'm not going to do that. I'm not going to write that check every year. So we're going to address that. And if we decide we want to get into Medicaid Asset Protection Trust, that's another seminar. That's probably another meeting beyond your estate planning, basic estate planning meeting. I don't want to confuse you with that right now or get into it too much, but we do that for a lot of people at another time in your life when it becomes more important. We know there'll be no death probate. We know that with the legacy plan, we can help identify those things that are important, get those put in writing, make that part of the family legacy. So now we've covered and created protection for all these issues that come up. And you see there are a lot of boxes on that screen. Whether it's death probate, living probate, nursing home expense, remarriage, divorce protection for your children, a lot of issues there. Now let's talk about giving the money to John and Susan. An outright distribution, we've talked about, well, maybe, maybe not. But what we now speak to people about is, well, there are other options. So sometimes we have people say, well, let's just hold it in trust for the children. And first of all, I want you to understand how this works and see how it works. And this is a pretty good visual of how it works. Just imagine a tube of toothpaste. And that tube is a trust. And if you put provisions in that trust that squeeze down on that tube, and what comes out is income and some principal that you can determine by what you put in your document, that's how it will operate for the benefit of your children. Here's an opener, an eye opener. We now have people coming in who have 35-year-old children who had outright distributions to those children, and the children are fully capable. And they talk about changing their plan to hold the property in trust for their children until the children reach 60 or 65, because they're convinced their children will have no Social Security. Isn't that a little bit of a mind opener? So again, people are being a little bit more thoughtful about all this than they used to be. So for example, with John, we could set up a trust of one kind for him, a different kind of trust for Susan, and split the money. So for example, with Susan, capable, confident, skilled, we could set her trust up so that she is the beneficiary, which means she gets to do what with the money? And she's also the trustee, which means she gets to manage it. And she can make the decision about whether she wants to keep that property in that tube of toothpaste or take it all out. She can decide based on the quality of her relationship, because that will evolve over time, and you may not know. And if she decides the day after you die that she doesn't need that tube, she can stomp on it, all that money comes out, she can take that, do with it whatever she wants. That's her decision. On the other hand, if she's a little concerned about Jason, which the slide shows she is, she could say, you know what, I think Mom and Dad did a good thing here. I want to leave this in trust. If we want to buy a house, I can put my share in for a down payment. I can help buy a new car. I can help educate the kids. This is money for me that my parents left me, and I'm going to determine the extent to which and when I take it out. Not a bad way to think about it. Would that work for John? Probably not. You know, we don't mind if John is the beneficiary, which means he gets to spend some of the money, but what do you think about John being the trustee and managing the investments? Probably not. So in that case, we call that a Century Trust, and in that case, we have an independent trustee do that. We have a trust company, we have a bank trust department, someone like that. And by the way, if you need a Century Trust in your family, spending money for that independent trustee will be the smartest money you ever spent. They're good at it. They know how to handle it. They've dealt with tough situations before, and they'll do it the right way. And there may be incentives you want to put in John's trust. Do certain things, create certain achievements, and that'll trigger more distributions. So basically, we want to give him an opportunity to elevate to good guy status, right? And there may be a time when the trustee says, you know what, you're squared away, successful guy. Now I'm willing to do a little different distribution on this trust. And it can be drafted so that that works. So again, we've talked about this. What we don't want to do is this. We don't want to leave behind family disputes. We don't want to leave behind court hassles, fees, taxes, etc. Not a responsible thing to do. It's just not. Particularly when it can be avoided. So that's why it's important. That's your why. Everybody has their own why. It's important to think about that. Why is this important for you to do this? Why is it important to think about it? A little bit about our process. 7 steps. Consultation. Plan design. And by the way, when you work with us, you pay us 0 for the documents. Where do you think we earn our money when we work with you? We're on this list. We're going to ask you a lot of questions. We're going to ask you questions that you've never thought about. We're going to probe and dig in the nicest, friendliest, most comforting way, but we're going to get from you the way you really want to express yourself in this document. We may even quote you in your document. We may use your words. I find myself saying in consultations, tell me how you'd like to have that expressed. I'll tell you if it's going to run you over the cliff, and I'll pull you back. But I want to hear from you, this is where we earn our money, right in there. All the rest of it's just paper. You pay for us because of our expertise, not because of the document, right? You pay for us because we'll be there for you when you need us. We'll be there when you need to call and ask somebody, what do I do now? You're not going to get that if you buy your document at Office Depot. So there are the 7 steps. One step here, step 6. Side note, we are also registered investment advisors. We help people manage money. We help people plan their retirement accounts, etc. We want you to walk through our financial analysis. That doesn't mean you have to do business with us. But if you're going to create a plan, we want to know and have the comfort that the plan you have in place is going to take care of you during the most critical times of your life. And this is a fabulous experience. And we also ensure you get all those assets transferred into your trust correctly. We take care of it from start to finish, from stem to stern. And then we stay in touch with you for a lifetime. We have people come in who have retained other lawyers, who have created plans 10 years ago, and we say, why are you asking us to help you? Well, our plan needs to be updated. Well, how do you know? Well, it's been 10 years. Well, who'd you work with? Well, I don't even remember. Have you ever heard from them? No. That will never happen with us. We will stay in touch with you. You'll get our newsletters. You'll come to our client events. Some of them are fun events. Some of them are education events. So there's an ongoing relationship there that you don't have to pay a penny for. And we want to be sure that we stay in close touch with our clients and we keep you up to date and we keep this front of mind awareness for you so we can keep it current so it'll work. So here's just 2 or 3 quick charts. This is all in your material of everything that's included in your Legacy Wealth Plan. And I'm not going to spend any time on that because it's the most comprehensive you can find anywhere. And again, all outlined in the material. And again, the Legacy Planning Booklet. And that's a fun thing to go through. Again, I mentioned the Medicaid protection, if appropriate, not tonight, but maybe at some point in time. Things are going to change in your life. We're going to want you to come in every 3 years and touch base with us. What's going on? Or you may get a note from us that says, look, there's been a big change in the law, and we think it may apply to you, so call when it's convenient for you. Come in for a consultation, and by the way, you don't pay for that. If you need work after coming in for that consultation, there's a charge. But we do everything on a fixed fee. Everybody hear that? We do everything on a fixed fee, and here's why I do that. I started my practice on a fixed fee basis because I got tired as a businessman of hiring lawyers myself when I needed help in any number of manners, and getting an estimate about what the fee would be, and then I get the final bill, it's twice what I thought what they told me. And I decided I'm not going to have a firm like that. That puts immense pressure on us. Because when you bill by the hour, that allows all my inexperience and my foolishness and my taking too much time to get your documents done, that passes all that risk on you, not me. When we quote you a fixed fee and tell you it'll be done in 30 days, who has the risk? We've got the risk. And I wanted to have a practice that was different in that way, so that's the way we do it. You may remember earlier in the program, we asked this question: what's the most important part of your planning? And you see on the screen, we happen to believe it's your choice of an estate planning attorney, someone who can help make sure that what's important to you is covered exactly the way you want it in that plan. We know that every single one of you has your own unique estate planning DNA, and it's very important that you work with an experienced attorney to help draw out exactly what you want through the appropriate questions. And it takes experience to learn how to do that. So it's very, very important you choose the right firm and the right attorney to help you go through this. Here's what you don't want to do. You want to be sure that you don't have a bare bones estate plan, a canned approach. Those that you might pull from the internet free or go to Office Depot and buy for $29.95. I call those drive-through documents. Instead, you want a plan that's designed specifically, again, for your family, as I mentioned before. A plan that answers the question, what's most important to you? And being able to work with someone who will ensure that what's important to you gets translated to that document. After all, this is not a document just for you and your family today. It's a document that could impact generations in your family for years and years to come. Here's what you have to remember. And some people refer to this as a dirty little secret, but the fact is some trusts don't work. In fact, some people say most trusts don't work. And they don't work because there's one significant step that's not taken that should be taken and must be taken. Here's why. Most people, most firms don't work with clients to be sure that the assets are transferred correctly into the name of the trust. No one took the time, no one took the effort to make sure that all the assets, whether it's an annuity, an IRA, mineral interest, a farm, business interest, your checking account, and so forth, are properly transferred into the name of the trust. Because remember, when you set up a trust, the trust controls the assets that are titled in its name. They don't control anything else. Anything else that's left out is subject to probate. So this is a critically important piece of the estate planning process, and it's a failure that we see made over and over and over. So be sure that you're not fooled. Be sure that you work with a firm and you create a plan that actually works. And that takes expertise, it takes time, and it takes some persistence to walk through all the steps that you see there on the slide. Now, having said that, let's talk about the investment. We know that we are not the least expensive firm in town. There are places you can go. You can find an attorney at the end of a shopping center, and you can probably get an estate plan of some kind set up for $1,000. We also know that you can go to a downtown firm, or many others in fact, and pay $10,000 and get half of the value and half of the service that we provide. Most of our clients invest somewhere between $4,000 and $6,000. And that all depends upon many of the estate planning options that you choose. There are a number of different choices you have to make, a number of decisions you have to make. But one thing we will tell you is when you come in and visit with us and we go through the discovery process, at the end of that we will give you a specific fixed investment quote, and you'll know exactly what it's going to cost at that point in time. Remember, as you think about this, what did our grandmothers always say? You get what you pay for. And whether it's parachutes, brain surgery, fire extinguishers, and so forth, estate planning falls in that category. Some of our clients come in and They want the basic plan. Sometimes we refer to that as the silver plan. They want to avoid probate. They want tax protection that's available to them. On the other hand, some people want a little bit more. They feel it's necessary to insert some of the more specialized provisions, whether it's divorce protection for your children or remarriage protection, creditor protection, so on and so forth. That will require a little bit more of an investment. At the top of the pyramid, you see the Platinum Plan, and that would include Medicaid planning, protecting your assets from the ravages of extraordinary and highly accelerating nursing home expense. And again, we sit down with you in all of these meetings, not knowing exactly what options you're going to ask for, but once we determine that, again in the discovery meeting, we will give you that fixed fee quote. In addition to just the plan itself, and I often tell people, look, your documents are free. What you're paying for is the value of our experience, the value of our expertise, the training we've had, and as I mentioned before, I think it's critically important that you work with someone who has the knowledge and ability and care to be able to visit with you to draw from you exactly what you want in your estate planning. In addition to the estate plan that's created for you, there are many additional value-added services that we include. The trust identification card, so that when you go into a bank, you can simply pull from your wallet a laminated card that tells people exactly how you want your trust assets titled. Unlimited phone support, and we do that simply because we want nothing standing between your question and the appropriate answer. We don't want the fear of you being billed $200 for a 10-minute phone call. So we try to encourage that type of ongoing support. We also allow for a free 3-year review with the staff so that you can take a look at your documents to be sure that everything's up to date the way you want it. As important would be what happens after the first death and the second death. So we also provide a free consultation for you, the surviving spouse, and your successor trustees, typically your family, to go over the plan and outline the necessary steps to take the trust to the next level and continue to serve you during that period of time. DocuBank is a service we also provide for 1 year, and that service allows us to take your healthcare documents and register those documents online. They issue you a card, again, be carried in your wallet or your purse, so that if you're out and about, whether you're in Virginia, Washington, D.C., state of Washington, Hawaii, overseas in Europe, and something goes wrong and you have to go into the hospital requiring care, they can dial that 800 number and the hospital or care provider will have your documents within just a matter of minutes. In addition, client appreciation events, client-only seminars. We also stay in touch with you 6 to 8 times a year through newsletters and e-alerts. The whole objective is we want to be completely different than most law firms. This is not a transaction to us. This is the beginning of a relationship. Many people that we retain who have created previous plans say they'd never heard from their estate planning attorneys anytime 15 years after the plan was created. For us, you are clients for life. We want to be your trusted advisor, whether it's in matters concerning your estate plan, your financial plan, or any other issues that may come your way during your lifetime. So as we think about this process, remember, knowing something's not enough. We know a lot of things. We know what it takes to lose weight. We know that if we move more and eat less, we're going to maintain or perhaps even lose weight. Well, knowing that is the easy part, right? We all know how to do that, yet it's a challenge for some of us. And the same can be said of your estate plan. You now know more than you did before, but now what's required is the action plan part. So the questions are, what do you need to do and how do you make it happen? When should you get started? And the investment. And we've covered those as we've gone through this program. Picture this, put yourself in this story. I have a sore throat. I'm a healthy 56-year-old business guy, own a farm. Actually, the farm that I was born on. Doctor says, stay at home, don't go to work today, rest your voice. But I'm not a sit-around guy, so I get in the pickup and I think, there's always work to be done at the farm. chores to be done. So I drive to the farm, and when I pull up, I can see lots where I can help a lot. So I decide to pull up to the barn. I get on the brand new 4020 John Deere tractor, and I go out and I decide that I can help bring some of those big round bales laying out in the field back up to the barn where they're being kept. So I get on the tractor and I go down the hill. A little moisture on the ground, a little dew on the ground, and it's still early in the morning. My wife got up early. She had to go to a function, won't be back till mid-afternoon. She left actually before I did. I left her a note, told her I'd be home about 6. So I take the tractor and I back it into a big round bale. Then I release the clutch and the tractor starts to move, put it in gear, tractor starts to move forward. Going down a hill, make a turn, maybe too sharp a turn, and the centrifugal weight of that 1,000-pound bale starts to move that tractor, that huge John Deere tractor, and it starts sliding. And before I know it, I'm below that tractor, flying through the air. Tractor rolls on me, lands on at the bottom of the ditch on all fours, and pins my left leg. And now suddenly, all kinds of thoughts start rushing through my mind. Because I remember that my son asked me to create an estate plan 6 months ago, and I fiddled around with it, and I didn't get it done. And what about the farm? And who will help manage my business? And what about my wife of 35, 40 years? And what about, and what about, and what about? Until my last thought is, now it doesn't matter. That was my father that died underneath that tractor without an estate plan. So he became the inspirational founder of this firm. He became my reason why, after all these years, why I stand in front of groups like you tonight and share this story. This is important because we never know when it might happen to us. We fought the IRS for 3 years, probate for 3 years, over a small farm and a family-owned business. So it's a little different world than it was back then, but the point in the story is still the same, repeated too often. So I just encourage you to take advantage, find out more, don't let this happen. This is the ostrich theory of estate planning. We just kind of put our head in the sand about some of these things. But when you come in, we'll just have a dialogue about what's important to you, how important is it to you, what do you want to do, what would you like to see done, and then you can decide how you want to move forward. Okay, so I always ask this question, what legacy do you want to leave? What will you be? When people look at the tracks you leave, what will they see? Okay, thanks for being here, folks. Good to have you with us.